Welcome to Protecting Your Legacy with Estate Planning.
Hello and welcome to Protecting Your Legacy with Estate Planning with Adam Grant. I'm Chelsea Reynolds. Adam is the founding partner of Stonewood Law Group PC in Encino, California. With over a decade of legal experience, he focuses on estate planning, probate, conservatorships, supplemental needs trusts, and entertainment law. Known for his client-centered approach, Adam helps Southern California families protect what matters most and build lasting peace of mind for generations to come. In today's episode, we're talking about trust administration. Welcome, Adam.
Thank you for having me.
So, Adam, when a loved one passes away and there's a trust in place, what are the very first steps that need to happen?
So yes, there's a lot of things that you have to do. First thing to do is review the trust. The trustee in that trust, or the subsequent trustee in this case, should know that they are the trustee. Perhaps they've been given that notice from the person who set up the trust, or the family goes looking for a trust and finds that they're the named trustee. They take that document, you can take it to an attorney, you can do it by yourself, but then you want to faithfully execute the terms of that trust. What does that mean? That means gathering all the assets, figuring out what assets were in the trust, perhaps what's not in the trust, and you may have to go through probate for that process. But if everything's in the trust, you identify the property, you identify the beneficiaries, you ensure you have those assets properly in the trust, and then you distribute those assets pursuant to the terms of the trust.
Who is typically responsible for administrating the trust, and what does that role really involve day to day?
Yeah, so there's three parties in a trust. There's the trustor, grantor, settlor. That's the person who sets up the trust. There's the trustee. That can be the same person as the grantor or settlor at the outset, and they can administer that trust on their own behalf during their lifetime in a standard revocable living trust. There's then the beneficiaries. So those are the people who receive those assets under the trust. The trustee, their job is to administer that trust, and they have faithful obligations, they're fiduciary obligations, which means they have a higher level of standard and care, and they have to follow the terms left by the trustor or the settlor. So essentially following out the instructions and wishes last left behind. Now, the trustee can be a professional fiduciary. So depending on the circumstances, you can bring in someone like a bank or a private fiduciary, and there's a whole field of professionals that do this job, that serve as trustees, so that they know which distributions are permitted, which instructions need to be followed, and how those instructions should be followed by the person who set up the trust.
How soon does the trustee have to start acting, and what kind of deadlines or legal notices apply in California?
Great question. So once you get started and the person has passed away, you immediately want to get into the administration and distribution process. What does that entail? Looking again at the assets, seeing what the trustor or settlor had in the trust, and then following out the terms of that trust. So perhaps you get the family together, you do a sitting or a reading, or you just advise the beneficiaries as the trustee what will be happening. And initially what happens is that trustee sends out a letter, and that letter follows the California Probate Code and the trust terms, and it gives the trustees the authority that they're asserting over the trust and letting the beneficiaries know what their plan is in terms of being that trustee and distributing the trust assets. There's then a time period by which the beneficiaries can object to whether the trustee is serving, what they intend to do with the funds of the trust, but that gives everyone an equal opportunity to ensure transparency and that the trustor's wishes are being carried out for full.
Okay, what kind of assets usually need to be transferred or retitled during administration, and how
Now
does that
that's
process work?
Yeah, that's a very heavy question, and that's why I think working with an attorney is very important. You want to make sure your trust is funded. If it's not funded, it's not in existence. It doesn't exist. Never got set up properly. So you want to make sure that the assets you put in the trust, A, ensure the trust is properly funded, but B, the right assets are in the trust, and ideally all your assets are going into the trust. Now, life insurance, 401ks, retirement accounts, those aren't going to go into your trust per se. What you're going to do with the help of an attorney, perhaps, is organize a method or an approach to these institutions to give them instructions to either change title on the assets or to name the trust as the beneficiary on the account. So here at our firm, we give letters to our clients so that they don't have to explain this process to the institutions. Rather, they know what to do. They get a confirmation letter back from the bank, and the change is super easy. It's made, and the asset is either retitled in the name of the trust or named as a beneficiary on the account, so that subsequent beneficiary on the account. So then when it does flow to that next person is the trust, and you can have it follow the terms of the trust in terms of distributions to those beneficiaries.
Very neat. Can beneficiaries expect to be involved like throughout the process, or is communication mostly between the trustee and the attorney?
So beneficiaries should and can expect to be involved in the process. Once the trustor, grantor, settlor, whoever that person is, passes away, or the last of them passes away, the trustee then steps in and it's their turn to administer the trust. At that point, the trust is irrevocable. Both settlors have passed, and the beneficiaries can expect to be informed of the process. So what that entails is that letter we last discussed, where the trustee is going to give notice to the beneficiaries, letting them know they are the trustee, how to be reached, and their plan of distribution. If they contest, the beneficiaries can, of course, contest that appointment or that reading of the trust or how they're going to distribute the assets under the trust, but they will be advised and should be advised under legal procedures of the trusteeship now transferring hands and the plan for distribution. So the beneficiaries, to answer your question, do become involved once that trustor, grantor, or settlor pass away.
Okay. What options are available for resolving disputes or confusion, and when, if ever, does the court need to get involved?
Fantastic question. So this often depends on how your estate plan is put together. Some, and myself included, attorneys will put in arbitration language or mediation language, allowing the beneficiaries and the trustee, in the event of a dispute, to resolve that dispute through amicable means short of the court formal process. So mediation, arbitration, having resolution there. If that's not in the trust, typically what happens is you would bring a trust contest at probate court. So that's a trust administration case. And that's largely what we're talking about here, is administering the trust. And if everything follows the terms of the trust and the trustees following those directions, then you never need to go to court. Presumably it all works correctly. If there is a dispute and there is no mechanism for arbitration or mediation, then you may likely end up at court for any dispute related to a trust.
How can an attorney help a trustee stay compliant and avoid personal liability while keeping things on track?
Yeah, so again, a trustee, when they become trustee of the trust that they're operating, managing, and administering, they have a higher level of obligations to the beneficiaries. It's a fiduciary responsibility. So perhaps they don't have the tools to faithfully execute the instructions. Perhaps it's a very complex trust with a credit shelter or marital deduction credit shelter trust, in which case you would want some assistance. You don't feel comfortable, and often the term provides for bringing on another party, either as a trustee to work alongside you, or providing the funds for a professional to consult with you. So you can then bring that trust to a CPA, to a lawyer, and they can help you make the distributions and follow the trust as it's written. So if you do have any concerns and want to make sure you're faithfully executing your duties, you can consult with a professional to ensure those duties follow the terms of the trust.
That's great to know. What tends to delay trust administration, and how can families prevent those slowdowns before they even start?
Yeah, so oftentimes I see trust administration slowed down by the families. Unfortunately, when money becomes involved and someone passes away, even close families tend to have some disagreement or a level of fighting, which prevents them from all getting on the same side or same page and bringing a coherent, cohesive, pleading or petition to the court for resolution. But you want to have everyone on the same page. So that's why it's very important after the trustor or settlor dies, that these relationships are maintained, that the trustee understands their obligations under the trust, and that the beneficiaries get what they're entitled to under that trust. And if they need help to administer the terms of the trust, if it's too complex, seek a professional's help. And that's where someone like myself would be happy to walk through the trust, help you understand what your obligations are in it, what you need to provide for the beneficiaries, and ultimately help wind down that trust when its purposes have been fulfilled.
Finally, once everything has been distributed, what does winding down the trust actually mean, and how does a trustee know when their job is done?
So with trust administration, you want to figure out who the trustee is, and if that's yourself, what your obligations are under that trust, and who the beneficiaries are. Once you obtain that, perhaps you need a professional to guide you, but if you don't, you can start distributing the trust and giving the assets to the people who are intended to receive them at whatever stages or with whatever conditions are on those. Once the money has been divvied out and the purpose of the trust has been fulfilled, the trust is then ready to be wound down. So how do you wind down a trust? A trust is wound down by giving similar notice to these same beneficiaries, providing an accounting that follows the California Probate Code, providing them a central overview of what assets were in the account, what's been sold, perhaps real property's been sold, and what the distributions are to each of the beneficiaries. They then get these letters. There's a time period. They sign off on the check or checks that they're entitled to. And when all that money has been distributed pursuant to the terms of the trust, you can formally wind down the trust by having these acceptances and proof of receipt from the beneficiaries acknowledging their receipt of their distributions.
Thank you for listening to today's episode of Protecting Your Legacy with Estate Planning. If you're serving as a trustee or need help navigating a trust after a loved one's passing, visit stonewoodlaw.com to connect with Adam. And don't forget to leave a review, and subscribe so you don't miss the next episode. Thanks again, Adam.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.